right. I think this is when I start talking. Welcome everyone to the Silicon Valley Regional Engagement Alumni Chapter. We are delighted that you've all joined us today, and we're all here for some, just a little light discussion about the future of democracy. So, it's late in the afternoon, so nothing too heady. Again, just the future of democracy. So, again, welcome. We're going to put into the chat a link to the calendar for other alumni events that are being scheduled. So take a look at that and see if there's anything else that you'd like to join us for. And I think with that, if you have questions that come up during Dean Chemerinsky's talk or at the end when we're doing a little bit more Q&A, please put those into the chat and we will try to get to everyone's questions about both the school and what's going on at Berkeley Law, and also the bigger picture issues that we'll be talking about this afternoon. So with that, Dean Chemerinsky, I'm going to turn my video off and mute myself and look forward to your talk.
Thank you. Thank you all so much for coming this afternoon. I want to do two things. One is I want to give you a quick update on what's happening at the law school. And then I was asked to talk about the future of American democracy and the path forward. Let me start with the law school. Overall, I have a lot of good news to report. There's no doubt that it was a difficult year. As I think you know, we were entirely online for all instruction. Our commencement, which will be a week from Friday, is all online. Brian Stevenson is going to be the speaker, and I wish so much we could all be together in the Greek Theater to hear him, but it will, at least for this spring, have to be via Zoom. The chancellor has decreed that there's going to be no live in-person commencements on campus for this month. And there's so much that's difficult about being online. I think everybody at this stage of the year is frustrated at the loss of community. I think that people are tired. Some people don't learn as well via Zoom. Some in our community have really had struggles this year. And yet at the same time, I have to say there's a sense of satisfaction that we did it, that we made the transition to online, and I believe we still provided excellent legal education for our students. I find one statistic particularly revealing here. The median student evaluation for non-seminar courses has been consistently about 6.01 on a 7-point scale. In December, for the fall 2020 semester, the median student evaluation was 6.10. I think that shows that the quality of education didn't decrease, even though we had to be online. The plan for the fall 2021 semester is to be in person. My position from the beginning has been that we'll be in person to the greatest extent possible, as allowed by the public health situation and campus rules. We had a faculty meeting this morning to discuss our policy, and I think there's unanimity that our plan is to be in person for fall 2021 instructions. There's no doubt that there's going to be difficult transitions. There's a lot that's unknowable at this stage. It's certainly possible there could be a flare-up of the pandemic that requires us to go back online. It's possible the smoke and fire season might require it, but our goal is in-person instruction. Let me tell you some of the other things that are going on in the law school. And again, overall, I think it's excellent news. Let me start with admissions news. Last year, we received about 5,500 applications for what was meant to be a class of 320 students. This year, we received over 8,000 applications for a class that's meant to be 320 students. There's been nationally an increase in applications, but ours far exceed what we've seen across the country. I don't have an easy explanation for why. I hope it reflects good buzz about Berkeley Law among prospective students. At this moment, and obviously this is May 12th, not August 16th when we begin, we have 385 confirmed students for a class of 320. That's not as alarming as it might sound, because there's always some melt of that. There's always students who get off the wait list at other schools or decide to defer or decide just not to go to law school. But at this stage, I'm much more worried about being too over-enrolled than under-enrolled. The numbers of this class are quite stunning. As of now, the class has a median LSAT of 169, which is a point higher than it's ever been in Berkeley law history. Median GPA is 383. The diversity numbers are terrific. There's 42 African-American students in the class, 66 Latinx students, 90 Asian students, 12 Native American students, 64% of the class would be women. Now, don't publicize these numbers. They can change tomorrow and change by August 16th, but certainly it's an indication of the strength of the class. Likewise, our LLM enrollment is up, both for this summer, about twice what it was last summer, and significantly up from last year, from this year for next year in the traditional LLM program. That could change even more dramatically, depending on whether students are going to be able to get visas to come. But at this point, everything looks great. We'll just have to see how it plays out. A second topic that might interest you is faculty appointments. We're adding 2 new faculty members on July 1st. Jennifer Chacon from UCLA Law School. She specialized in immigration law and constitutional law. Jonathan Glader, also from UCLA Law School, specialized in education law. It's a real focus on student debt and also teaches criminal law. If you look since 2017, which is the year I arrived, we've added 19 faculty members. Jennifer and Jonathan will raise it to 21 faculty members over a 4-year period. I don't think that any other law school in the country has added that many faculty members in such a short period of time. And they're really stars. I mean, I know Jennifer and Jonathan well and how terrific they are as teachers and scholars, but if you look at some of the other faculty we've added in recent years, David Graywell, who was a tenured professor at Yale, Jonah Gelbach, who was tenured at the University of Pennsylvania, Orrin Kerr from the University of Southern California, Kara Bridges from Boston University. They're just wonderful additions to the faculty. We still have a number of open slots. As of now, the tentative plan is to hire 6 additional faculty next year to begin July 1st, 2022. And my guess is over the next, say, 2 to 3 years, adding about 10 more faculty. Part of the faculty meeting today was to discuss what should be our priorities in terms of faculty hiring. Another topic that might interest you concerns the career opportunities for our students. And here too, the statistics are really encouraging. Career opportunities are measured basically 10 months after graduation. So we look at the class that graduated in May 2020, 10 months after their graduation. And this is what we have to report to the American Bar Association. For the class of 2020, our employment numbers were a bit over 95% for this class, and that's full-time JD required jobs. Now, at first, it might look like it's a bit down from last year. For the class of 2019, we were just over 98%. But the gap is actually smaller than that. The bar exam was several months later, as you know, in 2020 than it had been in 2019. And as a result, some students' job start dates were delayed. So there are 4 students who we know have full-time jobs, but hadn't started by March 1st. They're not counted in that 95%. If you include them, then we're at 96.5%. Or another way of looking at the statistic is that as of the beginning of March, when we had to report the data for the class of 2020, there were only 8 students who didn't have jobs or were looking for jobs out of a class of about 325 students. So the employment situation looks really good. And from everything we can tell from the class of 2021, it's going to even be stronger than it was for the class of 2020. For our current law students, especially our rising 3L students, the job market was quite robust. We're going to go back to on-campus interviewing in August, as we've done in past years. And I was going to look for an exact breakdown for you of what the students are doing. Roughly about 65% of the students have gone to, of the class of 2020, have gone to law firms. Of those, 90% of that group has gone to big law firms of 100 students. Roughly 20% go to government and public interest, and about 16% go right to judicial clerkships. And those numbers stay fairly constant from year to year. So the numbers in that regard are good. The only difficult note to sound with regard to the year is it was a tough budget year for us. We lost about $9 million in LLM revenue for this fiscal year that we had a year ago. Our LLM program this year was half the size that it was a year ago. And that's just a result of visa problems because of the pandemic. And so it was a loss of $9 million that we had the year before and that we had planned on. Campus cut its funding to us by $2.5 million, as campus had a huge budget deficit and cut its funding to all the schools. We get money from campus in two buckets. One is they pay our tenure track faculty salary and benefits. And the other, we get a good deal of money for running the undergraduate legal services program, like paying the cost of the instructors, the administration of the program. Net last year, we got about 7% of our budget from campus. They just simply took back $2.5 million of that this year. We get a total of $1.8 million from the Office of the President, and they cut that by $500,000 this year. So we lost $9 million in the LLM program, $2.5 million from campus, and $500,000 from the Office of the President. So altogether, that added up to a $12 million loss in revenue. Our budget this year is about $115 million. So losing $12 million out of $150 million is a significant hit. It's especially so because so much of our budget is fixed costs. 65% of the budget is faculty and staff salaries and benefits. 20% of our budget goes to student scholarships, and so much else is fixed costs. We're able to recoup most of that $12 million by not having to pay for travel, since no one was going anywhere this year, not having to pay for food for law school events, by keeping some staff positions unfilled, by tightening our belt throughout the law school. I was committed that we would have no layoffs of staff, and we did not need to lay off any staff. I was committed that we were not going to compromise our educational program anyway, and we didn't. We didn't reduce a lecture or the like. We'll end up with about a $1 million budget deficit this year, but we do have a cash reserve, and we are able to absorb that through our cash reserve. I'm hopeful that the LLM program will rebound next year, that we'll go back to having a budget that's in surplus, not in deficit. But in the worst case, we continue to have that cash reserve if we need it to be able to draw on it. So that's my overview with regard to the law school and where we're at. I'm certainly glad to answer any questions that you have, but the news overall is good. I'm not sure if you saw a memo that I wrote that contains our most recent rankings. I always have great trepidation before the rankings come out. There's so much that's arbitrary about the rankings. For example, what separates schools in the, say, band of 5 to 10 in US News, the most important factor is per student expenditures. If we could simply increase our per student expenditures by a significant amount, and let's say here about by $1 million a year, we would immediately go up in the US News rankings. It's actually even more arbitrary than that. We have the lowest tuition of any of the top 10 law schools. By virtue of that, we also suffer in per student expenditure. And US News, in its infinite wisdom, reduces our per student expenditure by a cost of living adjustment, and they add a boost to the University of Virginia's per student expenditures based on cost of living. If US News simply didn't do that, apply a cost of living adjustment, we would be ranked 8 rather than 9, just by that one factor. But we were ranked 9. The specialty rankings were particularly impressive. Some of these are ties. We're number one in intellectual property, number one in environmental law. We're number two in criminal law and criminal procedure. We're number three in business law. We're number six in constitutional law. We're number six in international law. We're number seven in contracts and commercial law. We're number nine in clinical education. I don't know of many schools that are across the board as strong as we are. If you want to compare us to Virginia, the school that's right above us in US News, we're ahead of them in all of the categories I just mentioned, except for one where we're tied. Again, that to me shows the arbitrariness of US News. But the bottom line is our ability to succeed is going to so much depend on having the resources to be able to compete with our peer schools. Well, that's my report on the state of the law school. Let me shift to the other topic that I was given to discuss with you tonight, and that concerns the path forward for American democracy. I never imagined in my lifetime American democracy would be in jeopardy. I never imagined my lifetime we would see what occurred in November, December, and early January 2020 and 2021. This is the first time in history that a president of the United States attempted to overturn the outcome of the election. It's the first time that we've ever seen in history that there was a concerted effort by individuals across the country to deny the individual who won the popular vote and the electoral vote the presidency of the United States. No form of government lasts forever. We look around the world and we see that democracies are there until they're not. But I don't think that we can be sanguine about the future of American democracy in light of what we've just seen. The guardrails of democracy held, and we should be thankful for that. The courts, for example, rejected claims of election fraud. The statistic here is stunning. By my count, 33 lawsuits were brought by President Trump and his supporters trying to overturn results of elections in particular states. In 32 of 33 cases, the courts ruled against President Trump and his supporters. The only case where President Trump prevailed was a relatively minor issue about letting poll watchers stand closer to see the counting of absentee ballots. Judges appointed by Democratic presidents and Republican presidents, judges who are known as liberals and conservatives, all came to the same conclusion. There was no evidence of voter fraud changing the outcome of the 2020 presidential election. If I had to commend a single decision, it would be that of the United States Court of Appeals for the Third Circuit. It's a case that came out of the challenge to the Pennsylvania counting. And the judge who wrote that opinion, Judge Stephanus Bibas, was an appointee of President Donald Trump. Judge Bibas was a conservative law professor at the University of Iowa and then the University of Pennsylvania, put on Third Circuit by President Trump. In the strongest possible language, Judge Bibas said, there was absolutely no evidence presented of fraud with regard to the Pennsylvania outcome. The same thing is true with regard to the other closely contested states, like Wisconsin, Michigan, Georgia, and Arizona. This is a moment when we should all be applauding the judges who set aside party and partisanship, fulfilled their oath of office, looking at the evidence and saying there was none. But what if some of those courts had come out differently? What if the election officials had behaved differently? We know that President Trump aggressively tried to pressure election officials in Michigan and Georgia to come to opposite conclusions what the vote tally indicated. He said to the Secretary of State in Georgia, just find me the votes to put me ahead. Or what if state legislatures had come out differently? We know that President Trump attempted to pressure members of the Michigan legislature and the Pennsylvania legislature both controlled by Republicans, to give their electoral votes to Trump, notwithstanding Biden winning the popular vote in those states? What if the vice president of the United States had capitulated to pressure from Donald Trump? Trump wanted Pence to certify states, electors from states different than those that corresponded to the popular vote. Trump, in essence, wanted Pence to make Trump, again, the president of the United States. It's conceivable that the election officials might have behaved differently, or the state legislators might have behaved differently, or the courts might have behaved differently, or that the vice president might behave differently. But that's what I meant when I said the guardrails of democracy held. And yet, I just on Sunday saw a statistic that indicates that 30% of the electorate and 70% of Republicans believe that Donald Trump was cheated out of the election, that he was the one who should have been chosen as president. What does it say for the future of our democracy when you see those statistics? After the November 2020 election and its aftermath in December and January, I decided that I want to write a book on the threat to democracy and the path forward in that regard. I'm at the earliest stages with regard to the book. I just signed a contract for it last month, and the manuscript isn't due until September of 2022. But I want to share with you some of my initial thinking. And the thesis of the book is that the Constitution had some deep flaws. For a variety of reasons, those flaws manifest themselves to a greater or lesser extent over time. But now we're seeing those flaws magnified. And those flaws that were built into the Constitution pose a real threat to democracy. Let me tell you what I mean and then try to describe some of the path forward. Think for a moment, what are the branches of government created by the United States Constitution? Well, one, of course, is the presidency. The Constitution says that the president is chosen by the Electoral College. If 49,921 votes had come out differently in Arizona, Georgia, and Wisconsin, that's the number of people who can fit into a sports arena, Donald Trump would be president, notwithstanding Joe Biden having won the popular vote by 7 million votes. In the 20th century, not once did the loser of the popular vote become president through the Electoral College. In the 21st century, we've had it twice, in 2000 and 2016. We almost had it in 2004. Had John Kerry won Ohio, he would have become the president, notwithstanding losing the popular vote. And as I said, we almost had it in 2020, at 49,920 votes come out the other way. Well, I'll put it to you in another way. States with 22% of the population can choose the president of the United States because of the Electoral College. The Electoral College was very much based on distrust of the people. You can read in the Federalist Papers, Alexander Hamilton saying, we need the president to be chosen by an elite that understands the issues. The Electoral College was created to help protect slave states. States with large slave populations were concerned that that population would not help them at all in the choice of president. Slaves obviously couldn't vote. A compromise was reached where that in allocating representatives for the House of Representatives, slaves would count as 3/5 of a person. The state's electors in the Electoral College is the sum of its representatives in the Senate and in the House of Representatives. So slave states got a benefit from their slave population in the weight they had in the Electoral College. This is not just hindsight. At the Constitutional Convention in 1787, Hugh Williamson, a delegate from North Carolina, praised the Electoral College as giving North Carolina credit in choosing president for its slave population. James Madison, a delegate from Virginia, said the same thing. For reasons I can explain, I think that the Electoral College is much more likely now than ever before in American history to be choosing somebody who lost the popular vote. I think it's a result of the realignment of the political parties along ideological grounds. I think it's a result of the deep partisan split in the country. Well, think of a second institution created by the Constitution, the United States Senate. The Senate from the beginning was anti-democratic, but has become ever more so. In 1787, Virginia, the largest state, had a population that was 12 times that in Delaware, the smallest state. After the 2010 census, California, the largest state in population, had 65 times more people than Wyoming. That tremendously exacerbates the lack of democratic governance through the Senate. Or I'll put it to you in another way, a statistic that I find stunning. In the current Senate, the 50 Democratic senators represent 42 million more people than the 50 Republican senators. There's another way in which the Senate has become more anti-democratic over time, and that's because of the filibuster. Originally, there was no rule in the Senate that allowed for an end of debate. And then a rule was created in this regard, but it allowed for somebody to filibuster. If you think of the movie Mr. Smith Goes to Washington, it involved Jimmy Stewart holding the floor of the Senate until he collapsed. And that's what the filibuster was. In 1975, the Senate changed these rules so that while a filibuster is occurring, the Senate can continue its business. No longer does a senator have to hold the floor of the Senate. All that's necessary is for a senator to indicate that he or she wants to filibuster. Then the matter won't be able to be voted on unless 60 senators vote for cloture. The result of this in practical terms is that everything except judicial appointments and cabinet nominations needs 60 votes to get through the Senate. I think that's unconstitutional. I think the Constitution specifies the few instances where it takes a supermajority. I think it's anti-democratic. If you think of the stimulus bill that got through, it was only because it was deemed a reconciliation bill. Every Republican in the Senate voted against it, would never gotten 60 votes. At the very least, I'd like to see the Senate go back to the talking filibuster, a rule that says that a cloture vote can be taken at any time to get rid of the virtual filibuster, but the problems with the Senate are even larger than that. Well, a third institution created by the Constitution is the House of Representatives. It was meant to be the democratic institution with people electing the representatives. But what's changed here is partisan gerrymandering has become so much more effective than ever before. Partisan gerrymandering, of course, is where the political party that controls the legislature draws election districts to maximize seats for that party. So, say a Republican-controlled legislature draws legislative seats to maximize the safe ones for Republicans, or a Democratic-controlled legislature does that for Democrats. Partisan gerrymandering is nothing new. It takes its name from a governor of Massachusetts early in American history, Elbridge Gerry, who engaged in the practice. But what's different is because of sophisticated computer programs, partisan gerrymandering is so much more effective than ever before. Take the example of North Carolina. North Carolina is basically a purple state. It went for Obama in 2008, went for Republicans in the 3 elections since then, but it's always been by a very close margin. Republicans gained majority of both houses of the North Carolina state legislature, and they engaged in partisan gerrymandering. They said their goal was to give Republicans control of 10 of 13 congressional seats from North Carolina. The report was candid. It said it would give Republicans control more than 10 if we could draw a map to do that. They had a computer draw 3,000 possible different ways of drawing election districts. They picked the one of the 3,000 that maximized the chances that Republicans would win 10 of 13 congressional races. In 2016, and again in 2018, Democrats and Republicans across the state had almost exactly the same number of votes cast for congressional seats. But Republicans won in both those elections 10 of 13 congressional races. And of course, the partisan gerrymandering isn't just for the House of Representatives. It exists for state legislatures as well. There are a handful of states like California that have independent districting commissions. But in all other states, the legislatures can engage in such gerrymandering. In 2019, the Supreme Court considered whether partisan gerrymandering violates the Constitution. The case involved North Carolina and what I presented to you. In a 5-4 decision, the Supreme Court held that challenges to partisan gerrymandering cannot be heard by the federal courts. It's a matter just left to the political process. The 5 conservative justices, Roberts, Thomas, Alito, Gorsuch, and Kavanaugh, were the majority. This means that legislatures after the 2020 census, when they engage in redistricting, can engage in gerrymandering with impunity. There's one other institution created by the Constitution beyond the president, the Senate, the House, and that's, of course, the Supreme Court and the federal courts. Here, too, it was meant from the beginning to be anti-democratic. After all, the Supreme Court justices and federal court judges are appointed by the president and confirmed by the Senate, and they serve for life. There's no democratic check. This was, and I think it's laudable, to create an independent judiciary. We don't want justices or judges to decide cases based on what's necessary to please the voters. But because of historical accidents and manipulation of the process, there's been a tremendous imbalance over the last 60 years. Between 1960 and 2020, a period of 60 years, we had 32 years with Republican presidents and 28 years with Democratic presidents. As of 2024, astoundingly, we've had 32 years with a Republican president, 32 years with a Democratic president. But since 1960, Republican presidents have appointed 15 justices to the Supreme Court. Democratic presidents have appointed only 8 justices to the Supreme Court. So even though they're even in years in office, it's basically a 2-to-1 ratio favoring Republicans over Democrats. So some of that is just the historic accident of when vacancies occur. Some of that, though, has also been the manipulation of the process. Remember, Supreme Court justices serve for life. John Paul Stevens didn't retire until he was 90 years old. Life expectancy today is thankfully a lot more than it was in 1787. In 1787, the average life expectancy was just 36 years old. Let me give you a specific example. Amy Coney Barrett was 48 years old when she was confirmed for the Supreme Court on October 26, 2020. If she remains a justice until she's 87, the age was Justice Ruth Bader Ginsburg died, Barrett will be a justice into the year 2059. This heightens the anti-democratic nature of the Supreme Court. Or another statistic. Think of Brett Kavanaugh. He was appointed by a president who lost the popular vote by 3 million votes. He was confirmed by senators who represented 44% of the population in the United States. Kavanaugh is just 55 years old. If he stays until he's 90, the age Stevens stepped down, he'll be a justice for the next 35 years. So those are the institutions of government and why I'm concerned about American democracy. As I say, the flaws existed from the very beginning, but they've only gotten worse for a variety of reasons as time's gone on. At the same time, what I see as I look across the country is a threat to democracy in another way, and that's a systematic effort to suppress the right to vote. When you look at what the Georgia legislature, what the Arkansas legislature, what other legislatures are doing, There's no doubt that this is an effort to make voting more difficult. It's especially to target Democratic voters, who tend more to vote by absentee, and especially voters of color. These laws are being challenged in the courts, though for reasons I can talk about, it's quite uncertain what the outcome will be. Race was a fundamental flaw that American democracy was based on from the very beginning. Slavery was protected by the Constitution from the outset. And we continue to see the manifestations of that racism as we look at the suppression of vote across the country. Well, what I want my book to do is to suggest a path forward for American democracy. I'd like to see electoral college reform. I would like to see the electoral college eliminated, but I don't see any way that that would happen. It would require a constitutional amendment, and the small states that benefit from the electoral college would never vote to ratify such an amendment. I'd like to see a way of eliminating winner take all. In 48 of 50 states, all but Maine and Nebraska, whoever wins the popular vote gets 100% electoral votes. If you voted in California for Donald Trump in November, your vote was meaningless. If you voted for Joe Biden in Texas, your vote was meaningless. Is there some way to get proportionate allocation? There is a proposal, the National Popular Vote Compact, where states would agree that they would give their electoral votes to whoever wins the national popular vote. I'm skeptical about this. In part, no red states have signed on. And in part, it's unenforceable. Imagine this year, where Joe Biden won the popular vote, if Texas had subscribed, would they really have given their electoral votes to Biden? Especially if the awarding of those votes was going to be decisive. I'd like to see changes with regard to the United States Senate. The changes that we most need would not be possible under the Constitution, and that's allocating senators on the basis of population rather than per state. Article 5 of the Constitution precludes that from being changed. But I do think that it would be possible to change the filibuster. My ideal would be the Senate would eliminate the filibuster to restore a majority rule in democracy. But if they won't do that, to at least go back to a talking filibuster to make the filibusters much less likely to occur. I'd like to see an elimination of partisan gerrymandering. It can't come from the federal courts because of Rucho versus Common Cause, but it can come through state courts. The Pennsylvania Supreme Court found partisan gerrymandering violated the Pennsylvania state constitution. It can also come from more states having independent districting commissions. To me, the most important changes with democracy need to happen with regard to Congress. There's a bill that's passed the House that would tremendously reform voting in the United States. Among other things, it would protect the right to cast absentee ballots. It would require independent districting commissions for House of Representatives seats. It would restore the Voting Rights Act, where key provisions were declared unconstitutional by the Supreme Court in Shelby County versus Holder in 2013. The concern, of course, is in the Senate, the filibuster is likely to preclude it from being adopted. In fact, the filibuster is likely to keep the Senate from adopting any reforms. And I think that the path forward for democracy has to include protecting the right to vote, and it has to come through a voting rights law. I wish that senators like Joe Manchin would be willing to create an exception to the filibuster, at least for democracy reinforcing laws like this, but so far he's been unwilling to do so. I am more worried about the future of American democracy at this moment than I've ever been in my life. I think we all need to be worried about the future of American democracy. We can't assume that the guardrails of democracy will hold next time. That's why it's incumbent on all of us to be thinking about what's the path forward. So I was asked to talk for about 40 minutes. I'm glad now to take questions, comments about the law school, about my book project, about anything else you want.
So thank you, Dean Chemerinsky, for the sneak preview of your book and for your comments on these profoundly important issues for American democracy. I also wanted to thank you for the fantastic news about the school, and especially about this fall's incoming class and the career opportunities for our recent grads, who I think a lot of the alumni have been concerned about that. So thank you for sharing that good news. And before I get into some of the very interesting questions that have been posed, just before this meeting, you shared some important personal news from this afternoon, and I wonder if you would share that with people.
Oh, that's so sweet. My granddaughter, Amy Chemerinsky, was born this afternoon at 1:15. Amy and her mom, Kim, are doing well. This is my third grandchild, and very happy to welcome Amy to the world.
Well, congratulations, and I'm glad to hear that mom and baby, and hopefully everybody else is doing well. So we've got several interesting questions, and I'm just going to pick a few that are most interesting to me. What are your thoughts about the removal of Liz Cheney from her Republican leadership position? And I'm actually going to marry that with a second question, which was yesterday we saw an article with the headline, "Over 100 Republicans, including former officials, threatened to split from the GOP." Can you comment about what's going on in the Republican Party on those fronts?
There's an excellent column by Thomas Friedman in the New York Times this morning that I encourage you to read. And it is about this. And it really goes from the premise of, what does it mean for the future of democracy if 30% of the country and 70% of Republicans believe that Donald Trump had the election stolen from him? What does it mean that a representative who says that this is just false, who condemned the president for inciting insurrection, no longer has a leadership position in the Republican Party? I saw another article in the paper this week that describes how the political polarization in the United States that has grown so much is larger than that in European countries. What's the future of democracy when you have this underlying division, when you have so many people who, notwithstanding the facts, are saying that the election was stolen? It's part of what makes me so worried.
All right. I'm going to pair a couple of other questions that have come in. And the short question is your thoughts on Facebook's ban of former President Trump. And I'm going to pair that with a longer question that I'll read. What significant legislative and regulatory steps can and should be taken consistent with the First Amendment to regulate misinformation, foreign and domestic, in the media and online, including reinstating the Fairness Doctrine?
Let me take each of those questions in turn. In terms of the Twitter ban, I wrote an op-ed for Bloomberg that came out about January 8th, criticizing Twitter for the ban on President Trump, and I would say the same thing in terms of Facebook. I think that it is, let me be clear, there's no First Amendment problem with this. Twitter, Facebook are private entities. The First Amendment doesn't limit what they do. They can include or exclude whoever they want. But Twitter and Facebook and YouTube are so important for speech. Donald Trump had 88 million followers over Twitter. By Twitter taking him down and banning him, it kept him from speaking to 88 million people who wanted to hear what he had to say. I think it's completely appropriate for Twitter or Facebook to take down speech that's inciting or threats or defamation. But I would criticize here the lifetime or the however long the ban lasts of Trump. I mean, personally, I'm thrilled that we don't have to have Trump in the news all the time with his tweets. They're nothing but divisive and destructive. And yet it bothers me that Twitter exercised the power in this way. So I don't think Twitter or Facebook should ban Trump, just take down the messages that are incitement or threats or the like. In terms of misinformation, generally false speech is protected by the First Amendment. There was a Supreme Court case about 9 years ago, United States versus Alvarez. It involved a federal law, the Stolen Valor Act, that made it a federal crime for a person to falsely claim to receive military honors or decorations. And the Supreme Court declared it unconstitutional. And Justice Kennedy's opinion is quite explicit that false speech is generally protected by the First Amendment. Now, there's exceptions to that. So, for example, false and deceptive advertising is not protected by the First Amendment. There can be liability, at least in certain circumstances, for defamatory speech, false speech that's injurious of reputation. The internet is the most powerful tool for communication to be developed since the printing press. It tremendously democratizes the ability of people to reach a large audience. Anyone with a smartphone or access to a modem can reach millions conceivably, billions conceivably of people. It used to be, in order to reach a mass audience, be rich enough to own a newspaper or get a broadcast license. But the difficulty in that and speech being so cheap is that it can be false speech that gets circulated. And how do we deal with false speech over social media? There's no answer to that. I'm afraid of giving anyone the power to decide what's true and what's false and to suppress what's false. I worry that if today it's Donald Trump who gets censored, tomorrow it's liberals who get censored. I always tell my students the only way their speech will be secure tomorrow is to protect the speech that they don't like today. I don't think the fairness doctrine was a success as it applied to the broadcast media. And though the Supreme Court upheld it in Red Lion Broadcasting versus FCC in 1969, I don't think this court would uphold the fairness doctrine. I'd like to see more government regulation, though, of social media, but in a content neutral way. For example, this gets to Section 230 of the Communications Decency Act. I think if a social media company has knowledge that speech on it is defamatory or a true threat or incitement, and if it doesn't then take the speech down, then it should be held liable. Section 230 says there's no liability if all it's doing is conveying information. I would say if it has knowledge that it's speech of that sort and it doesn't do anything, then it can be held liable. And I'm glad to elaborate much more on that.
What does knowledge mean? Going back to the comment that you made about somebody having somebody decide what's true and what's false. What does knowledge mean given that concern?
Well, I want to separate what the social media company knows or should know from a determination of what's true and what's false. Those are two different meanings or applications of knowledge. In terms of the former, we're all familiar as lawyers with the standard, you know or should know under the circumstances. And if Twitter or Facebook knows or should know under the circumstances that speech that's there is, quote, a true threat, it should be liable. If it knows or should know that speech that's there is child pornography, well, then it's liable. In fact, the Communication Decency Act was amended to stop things like Backpage, the FOSTA and SESTA laws. And so I think in that sense, if they know or should know that speech that's there meets certain categories, then they should have the obligation to take that speech down. That's different than saying they should make a determination of what's true and what's false and take down that which is false. I don't want them deciding the truth or the falsity of whether Donald Trump really won the 2020 presidential election. I think there we just have to trust that if all information comes out, people will come to wise conclusions. Maybe not, but the assumption of the First Amendment is that we're much better off with more speech than giving everybody the power to decide for us what's true and what's false.
Well, and I guess if there's 38% of people who believe that election was stolen, that does mean that 62% believe that it wasn't. So there's a question that I have to confess, I had to look up a word in it. So Britain had a plebiscite to exit the European Union. Is there any way to have a national plebiscite to address any of these reforms you discussed? And I will confess To the audience, that plebiscite was a word I had to look up, so apparently it is a referendum on constitutional.
Referendum, right? It's like a national referendum. We have the equivalent of plebiscites in California when we vote on initiatives. But there is no mechanism under the United States Constitution for a plebiscite, for a national referendum, for nationally voting on initiatives. Now, there's nothing that would keep Congress from creating one if it wanted to. I don't think it could be binding, because I think that if Congress delegated its power to the national plebiscite, that would be impermissible. But Congress could certainly decide it wants to create an advisory national vote on an issue. But no, at the state level, in many states, there's the ability to adopt laws, amend the Constitution by initiative. The Constitution creates no such process, and nothing like it has ever been held in American history.
So I learned that new word for no reason.
Well, it's an important word. When you talk about the California initiative process now, you can say, well, it's like a plebiscite here in California.
All right, I will do that. All right, I'm going to pair two more questions again. Should President Biden support increasing the number of Supreme Court justices, and is there any chance he will do so? And I will pair that with, do you anticipate that Justice Breyer will announce his retirement?
As to the former question, there is no way in the world that an increase in the number of Supreme Court justices will get through the United States Senate because of the filibuster. Obviously, the Republican senators aren't going to give Biden the ability to add 2 or 4 more Supreme Court justices. They would filibuster it. And in light of the fact it can be filibustered, there's no point in Biden supporting it. I think there's an argument for it in terms of restoring ideological balance to the Supreme Court. I think there's an argument that what we saw was court packing, and the way Merrick Garland's nomination was blocked and Amy Coney Barrett's was rushed through. But it's really, at this stage, it's an academic discussion, because there's no way that an increase in the size of the Supreme Court is going to ever get through the United States Senate unless the filibuster is changed. In terms of Justice Breyer, I wrote an op-ed that was in the Washington Post on Saturday, urging Justice Breyer to retire at the end of this term. In March 2014, I wrote an op-ed in the LA Times encouraging Justice Ginsburg to step down at the end of that term. There was at that moment a Democratic president and a Democratic Senate. Anyone President Obama would have nominated would have been confirmed by the Senate. I said, it looked like the Republicans were going to take the Senate in November 2014. They did. And I said, it's impossible to know what's going to happen in November 2016. And that sure was an understatement. And I said, if Justice Ginsburg wants someone with her values and views to take her place, now this summer is the time to step down. I never imagined that Justice Ginsburg would pay much attention to what a law school professor dean in Southern California was saying. But she did. She took great offense. She gave a number of statements where she said, some, like Erwin Chemerinsky, say that I should step down and I'm not going anywhere. No one can do this as well as I can do it. I heard from many people who would be usual ideological allies very critical of my suggesting that Ginsburg step down. Justice Ginsburg gambled that she would be able to remain on the court until a Democratic president could replace her. She gambled and we lost. And somebody at the opposite end of the ideological spectrum is going to be there for decades to come. I hope Justice Breyer doesn't make this mistake. I have no idea what he's thinking. But one interesting fact, when I did the Ginsburg editorial, which is in the LA Times op-ed, I got dozens, hundreds of angry messages. I wrote the same thing about Breyer on Saturday, and I got a handful, just a few. Probably it's because Ginsburg was an icon in a way that Breyer hasn't become an icon. Maybe it's because we saw it happen with regard to Ginsburg, but it is an interesting contrast.
Yeah, hard not to see that it, or to imagine that the experience with Justice Ginsburg hasn't affected people's reaction to the suggestion for Justice Breyer. All right, we have time for just one more question, and the question is about the possibility of DC becoming a state and how that would affect the reforms that you have suggested. And I'll throw Puerto Rico in there as well. So you've got a minute and a half, so that should be plenty of time.
I think if DC and Puerto Rico became states, it would lessen the extent to which the Senate is anti-democratic. I think as a matter of basic principles of democracy, DC should become a state, and Puerto Rico, if it chooses to, should become a state. Isn't it unconscionable that DC and Puerto Rico have no representatives in the House, no senators? Puerto Rico doesn't get to cast votes in the Electoral College. Isn't this taxation without representation? Is there any principled reason why we're denying DC and Puerto Rico statehood other than Republicans perceive they'd likely be two more Democratic senators from each, and they don't want to have that, but pure partisanship? Again, the reason it's not going to happen is the filibuster in the Senate. Senate Republicans certainly aren't going to give DC and Puerto Rico statehood and add to the Democrats in the House and the Senate. So unless the filibuster is changed, this too has no chance.
Right. Well, thank you, Dean Chemerinsky, for all your comments. Sounds like the filibuster, that's our first project. So that's our path. I am looking forward to when we can start having in-person events again, and when the Silicon Valley chapter, alumni chapter, can get together in person. And that should be coming soon, hopefully. If anyone, thank you to everybody for attending this evening. And if anyone has any suggestions for Silicon Valley chapter events or would like to sponsor an event, shoot me an email. I'm boyd@turnerboyd.com, and we will get things on the calendar very soon. So thanks so much.
Thank you all for coming.